We know we're going to go to trial. So I know immediately my client is negative $100,000 just paying me to go all the way to trial. We sell a case for like 15 grand. And I bill like 5 grand. But, you know, once we unrung the bell, because the plaintiff's lawyer wanted to go to the trial and being able to say, you know what they would have done with a go to hell letter? They would have said,
how different would it be if the same thing started looking now like it wouldn't change if nothing else really did? Subscribe and hit this like button and share this with a friend. Hey, this is Journey with Christian D. Evans podcast. This is Christian D. Evans coming at you. I thank you so much for listening to this. We interview top-level 8- and 9-figure entrepreneurs, business owners, and CEOs that have either had an exit or they are actually running and scaling their business to that billion-dollar valuation. We've also interviewed top-level TEDx speakers as well as incredible psychologists, also a lot of wealth managers that manage $1 billion to $200 billion and more. We've had incredible guests like Sachin Kajarian, Cameron Harold, Jay Abraham, and so many others. So if you find this of value, then share this with a friend. And we really appreciate it. Guys, show our guests some love by liking this and subscribing. And guys, until next time, remember, be uncommon if you can, and enjoy the episode. Cheers. Thank you so much for tuning into Journey with Christian D. Evans podcast. I'm your host, Christian D. Evans. The Disruptive Lawyer's Little Black Book of Litigation Management. He is the co-author of this book. He's also the founding partner of Cruser Mitchell, Novitz, Sanchez, Gaston, and Zimmett law firm. Over the last 30 years, this man has developed a reputation as a nationally recognized, aggressive, and creative trial lawyer who can handle the most complicated and high-dollar matters. From complex commercial class actions to sophisticated EPL, professional E&O, and civil rights matters. He has also a reputation with clients for resolving the unresolvable and has become regional and national counsel for a number of clients in high-exposure cases. Please welcome the founding partner of Cruser Mitchell, Novitz, Sanchez, Gaston, and Zimmett law firm, my friend, Bill Mitchell. How you doing today, Bill?
Hey, Christian. Great to be here. Thanks for the introduction. It's an honor to be here.
Well, Bill, I am looking forward to this conversation, and I want to build this first question. We're going to dive right into it, but let's build a little context. In the Disruptive Lawyer's Little Black Book of Litigation, this is what I think. This is the catalyst that helped build the firm that you have now. You assess the new cases and agrees it was an MSJ case. Now, some of these people don't know what we're talking about, but in context. But you decided in serving this discovery and taking deposition, you decided a different direction. You set out to convince the plaintiff's counsel to dismiss the case against his client due to its lack of merit, and instead direct his attention to the other case defendants. It worked, and you secured a voluntary dismissal from the plaintiff's counsel without any discovery. Now, the fee was only for $5,000, and it could have been $70,000 fee budget. And so some people in the case was closed with 6 weeks of the assignment. Some might say law firm, your firm could have lost 65 by not litigating the case. But in fact, you thought long-term, which I thought this was really cool. And the result and the process that produced it led to hundreds of cases and were instrumental. Now, there's 2 things that I want to share building this context. One, that was the catalyst to obviously building the incredible law firm that you now have, which has dozens of attorneys over several states, but also the paradigm shift, the unorthodox approach in which you approach that case. So I want to ask you, Bill, where did that come from? What was that thought process? How did you come with that unorthodox approach?
I wish I could say, Christian, it was my idea, but I wasn't that smart. I worked for a big firm in Atlanta, and we had a billable hour requirement minimum. And the minimum essentially requires you to be there at least 50 hours a week. But that was the minimum. And so we were working 60, 70 hours a week. I worked 5.5, 6 days, at least 6 days a week, my first 6, 7 years as a lawyer. And I was a young guy, and I'm begging this new potential client to give me some work. And actually, I do civil defense work, defending corporations and insurance companies in a wide array of cases, from, products liability to employment discrimination to, engineering malpractice. So I was begging this insurance adjuster. He was a VP of claims, to give me a shot. And he had no reason to give me a shot, and he shouldn't have given me a shot. I was a 5th, 6th-year lawyer, so he shouldn't have given me a shot. But one day he called me and he said, Bill, I've been working on this new book of business. We have a new client and they have their own counsel. They've been using this counsel for several years, and I've been using her for about a year. And I'll tell you what, we've given her 10 cases. She's 10 for 10. We've won all 10 cases, but every case has cost us about $100,000. We just got this new case in. It's a sad case. It's a death case. There's 5 defendants. We have one of the defendants. We hired her again, and she gave a budget and an evaluation saying, we're going to win. It's going to cost 70 grand, and I'll be able to file a motion at the end and we'll win the case. And then she got a conflict. So he called me and said something very, very simple. He said, here's the deal. Get rid of the case quicker and cheaper, and you're my lawyer. And I had never heard that before. My goal had always been to, ethically bill as much as I can and work as hard as I can on cases, and fight as hard as I can, thinking that would lead to better results. And when he said that, it was like Bizarro World, right? We're flipping what we do. So I had to rethink how to approach the case. It changed my paradigm of how I think of cases and attack cases. And, the stars aligned. I might have developed or realized I had a skill set that I didn't appreciate at that time I was a 30-year-old lawyer, and I was able to go to the other side. And after 2 or 3 or 4 conversations and a couple, I used honey and vinegar. And at the end of about a few weeks, I got the lawyer, the plaintiff's lawyer agreed to voluntarily dismiss my client, and I billed $5,000 on the case. And so when I went back to my partners and said, hey, there's this case out there, and I just did a great result for my client. They budgeted 70 grand. They were willing to pay 70 grand in legal fees, and I got rid of $5 grand. And, my partnership was like, what are you thinking? We lost $65,000 on that case. And as I tell people when I speak, I made millions on that case, because that client has used me for 20 years in 7, 8 different states. So it was a epiphany, and a brilliant epiphany provided by a guy named Charles Spencer, who was the VP at Hartford at the time, the Hartford, and it's been my litigation philosophy ever since. And I don't want to say I'm a one-man team advocating this. Slowly the industry has gotten on board, and there's a lot of naysayers and a lot of folks who attack the philosophy. And some have some legitimate concerns, which we can address today, but many do not. So that's the background.
So it's interesting because that individual, right, consciously or unconsciously, they put parameters around and said, hey, go out there, win this with less amount in a very short period of time. And so you had to figure it out. And you are big, and I love the disruptor kind of concept, right? Because it's like going out there, and that's what you guys are known for, disrupting it, right? And thinking unorthodox, which became almost a DNA of your law firm. My question is, when you're kind of integrating with new different strategies, or maybe even let's take this case, for example, what made you think, okay, hey, let's go directly toward the plaintiff. Let's go directly to and negotiate, because negotiation is also kind of your guys' almost secret sauce, if you will, because you guys are so good. That is part of your DNA of the law firm. So help me understand about how you integrated that and what that looked like.
Well, let's reverse engineer some things. That's, I think, as it became a more seasoned lawyer, I realized it's better to start at the end, and that way you can develop how attack a case. Through my writing and speaking, I started doing a lot of surveys and talking. I've talked to thousands and thousands of general counsels, risk managers, and insurance claims executives, and claims managers, and claims adjusters. This will shock you probably. What this all together in litigation, all cases in litigation, 1% of all cases go to trial. 92% settle, and then 7 or 8% get resolved through motions to dismiss or motion for summary judgment. So when I do my presentations and I do a negotiation series, I have a very, very simple question. If you know 92% of all your cases are going to settle, when do you settle them? After you pay your counsel $5 grand, 10 grand, 40 grand, 100 grand? When are you going to settle them? 92% settle. And so what you have to appreciate then, if when you change your paradigm and realize that that's the end, 92% of the time you're going to end up with a settlement, how can you attack and strategize to get there a lot quicker? And trust me, 1% go to trial, and you don't know what that 1% is. It takes a unique eye, a critical eye, and a talent to appreciate the 1% that are going to trial. And I added that. I do a presentation on identifying the 1%. And so there are, you're going to have to prepare probably 5 or 10 or 15% to go to trial that then won't go to trial. But going back 20 years ago, we prepared 99% of all cases to go to trial. The life of every case 10, 20 years ago would be a year or two. Today, our life of case is 60, 90, 120 days. And what does that mean? That means legal fees are a lot less. Cases, the longer cases go, the more complicated they get, the more expensive they get. And trust me on this, the more they cost to settle. On the civil defense side, we have a saying, a case rarely gets better for the defendant. We have all of the witnesses, the employees, we have all the documents, all the policies, all the procedures. So usually cases don't get much better than for us. Some witness, some ex-employee comes forward and says something we didn't expect. Some document comes forward that we didn't know about. They don't usually get better for us. So the best thing to do is get your arms around a case, evaluate it. And if you think it's going to be in the 92% bucket, aggressively find a way to move the case.
See, so let me ask you this then, and this is what I find so interesting about this, is when you're going into it, when we know that obviously this is outside of trial, which is a good thing, because then as a defendant or whatever that may be, you have a little bit more control around that. So what other techniques do you leverage that are very important when you know that you're running off of that baseline, that foundation, saying, hey, you know what, we don't want to go to trial because that's a lot of controls that we can't obviously facilitate. So what does that look like?
Well, trial is very unpredictable, right? So, and we all know this, 12 strangers walk in who have different philosophies, different beliefs, different, approaches to life. And so it's unpredictable. Georgia was just voted this year the judicial hellhole of the United States. We're getting cases I thought were worth $1 million 8 years ago are going for 10 million. Cases that were a couple million are going for 20, 30, 40, 50 million. It's outrageously crazy. You can't predict anymore. But what we're trying to do is every case has leverage, good leverage and bad leverage. And when I do my negotiation seminar, I'll start out by asking, the best way is give you an example. I'll start out and say, hey, ladies and gentlemen, let's say you just hired Bill Mitchell to handle one of your cases. And I reviewed the case and I said, hey, here's the deal. In every case before we start litigating, I give an evaluative report within 30 days, 60 days. And I say, here's the good, the bad, the ugly. Here's what I think is going to happen, or here's what I need to know before I can tell you what's going to happen. But in this scenario, I'm telling you, we're going to go to trial 10 times. We're going to lose 10 times. And the value of the verdict will be $1 million. And I look into the audience, I say, okay, we lose every time and the verdict's value is $1 million. What is the value of the case for settlement purposes at mediation? And people raise their hand. 90% will say, well, it's $1 million. And I'll say, well, wait, okay, that's trial value, mediation value. Let me ask you a couple questions. What happens if I told you that the plaintiff lives in Hawaii, the trial's going to be in Florida, and the plaintiff has 4 young children? Do you think she might take $950,000 not to have to go to Florida, or $900,000? What happens if we have the case that the plaintiff is a guy and we'll get evidence in that he cheated on his wife? Do you think he may not want strangers and maybe even his wife to know he cheated on her? So maybe he would take $700,000 instead of the $1 million. Right? And I just told you two scenarios that really had nothing to do with the law. So every case is a kaleidoscope. If you're a really good negotiator, every case has a million different scenarios that could be leveraged to help get a better result or a worse result. And really, really good lawyers anticipate, if they figure this out or they know this, we're in trouble. So we maybe need to act a little quicker to move the case. But I've been doing this for 33 years, Christian. In the last year, I've resolved 2 cases for much less than they were evaluated for leverage points I had never used in my own entire career. The stars aligned in these cases that these 2 leverage points that I've never thought about or used in my career perfectly fit into this case, these 2 cases, and we moved them for a lot less than we initially thought they were worth. So I have a leverage point checklist that is, it's 50 points on it, but literally there's hundreds depending on the specific case. And the problem we have, without filibustering you, is in our industry, the legal industry, in law school, I wasn't trained to negotiate. When I was a young lawyer, anecdotally, I watched my boss negotiate. If I went to a CE, continuing legal education, maybe I would learn mediation 101. I just went to a national conference 6 months ago, and they had 3 trainings. It was all for insurance people. And I was teaching there. I was teaching on litigation management, but there was there was a litigation management part. There was a, general liability part, a E&O part, and there was a mediation school. And I ran into somebody one day that I didn't know, and I'm talking to them, and I said, "Oh, you're in the mediation school." And the person said, "Yeah, we were there at 8 classes for 8 hours today." I said, So what was the best leverage point you learned of? And the lady looked at me and said, "Leverage points? You don't understand. This is mediation school." I'm like, "Well, you understand, like the fundamental foundational issue to mediation negotiation is leverage. Are you telling me you didn't learn anything about leverage or leverage points?" And she's like, "No, I think you're mistaken. I mean, that rule isn't applicable to what we're doing." And that's like saying, "Hey, we're going to go to football practice," and we don't ever bring out a football. I mean, it's kind of hard to practice if and don't ever get the pigskin out. So that's where we are fundamentally in this industry. Even on the other side, the plaintiffs' lawyers, and when I do this, I'm not trying. Yeah, I want the best deal for my client, and the best deal my client many times is there's low reasonable and high reasonable. And many times, and one of my biggest leverage point is educating the plaintiff's lawyer. Many times the plaintiff lawyer, we have all the information, many times the defendant. So it's advantageous to us economically and efficiently sometimes to go to the plaintiff's lawyer and say, "Hey, you think you're buying this beautiful mansion that's going to be worth $2 million? I'm telling you, it is a money pit. Your client's lying to you. Here's documents that prove it. And here's, I got 3 affidavits that I'll give you that will say that your client, which they're saying is wrong." And we'll settle the case for maybe a 0 or the cost of defense. And that lawyer's literally, "Thanks, I didn't know that." Because if you don't tell them at that point and they're 10 months into the case and they've spent 200 hours on the case and spent 20 grand on depositions and 20 grand on experts, and they're $50,000-$100,000 in the case, they can't walk away from it. So you have to be strategic and unconventional in how you approach these things. And the lawyers who attack this philosophy and claim people attack this philosophy, I call them dinosaur lawyers. And they will be extinct. It's just when, I'm not sure.
So with this concept of, you have a list of high leverage points, right? And whenever you go to a case, So my question is, when you're doing this, do you have like, okay, it's contextual. Here's the situation. These are the high leverage points. And then you're basically able to, align, okay, hey, these are the 5 or 6 kind of leverage points we're going to use in this circumstance.
Yeah.
And do you also have, because I'm a big believer in contingencies, right? Not that the plan A is not going to fail. It's just that you anticipate if it does fail, this is how we're going to counteract that. So what does that look like in regards to, okay, ensuring, hey, if they say this or they deny this amount of money to kind of, solve it outside of the trial, then this is our contingency. This is what we're going to do, et cetera, et cetera. What does that look like, Bill?
Great question. So we're playing chess, not checkers. So you got to think 2 or 3 moves ahead. For example, and this happened to me when I was a young lawyer. I had a case where I found some evidence against the plaintiff that pretty much I thought was fatal to their case. And I knew the plaintiff's lawyer very well on a personal level. So I went to him and said, hey, I got your client. We got some information, evidence on your client. You probably should walk or whatever. Stupid mistake by me. We took his client's deposition a week later, and she came up with the most crazy excuse to counteract what I had told him. And so when I tell you when I speak and tell and advise clients that we will share information, strategically you share information. Like if it's, for example, I've learned that lesson. If you some evidence, you might have to lock the plaintiff down before then you share it with them. Other stuff, I share evidence that there's no way they can get out of. For example, we do a lot of employment discrimination and breach of contract cases. So we might get a case where the plaintiff thinks it might be as simple as this. We're fighting about money. Not like we fired someone we shouldn't have fired them, and we breached the contract. Now we're fighting about money, and the person says they should get a $500,000 bonus. The old days, in 9 out of 10 other firms, what they would do is it would go into litigation, and we'd exchange documents. And after we exchanged documents, we would take depositions. I call it the deposition bleed. We do all these depositions, and after $50,000, $70,000. Maybe then we talk turkey. What I do in that case, and I do it all the time, is I'll call the other side and say, I know you thought your guy was going to get a $500,000 bonus. Rather than taking the CEO's deposition and the director of sales depositions for 2 days and prepping for 10 hours and double, come into my office next week. We're going to sit down and I'm going to show you the objective data that shows that your guy's bonus is actually $175,000. And we'll sit at a conference table. And guess what? Let's say the guy comes back and says, well, you don't have this document. It really is $500,000. I'd rather know then than bill $100,000. Then he springs it on me. And we're still, so it's either you pay, it might go away for 175 because I think I'm right. And I bill 10 grand on it, right? So the cost of the case is 185. Or if we have this meeting and we realize, oh crap, we actually do all the 500 grand. It will, if we resolve it, then it's 500,000 plus my fees is $510,000 versus we litigate 100 grand and then we settle it. So 510 versus 600. You understand the difference? So the quicker you get the parties together and educate each other, the more likely you can come to a resolution. And I've come up with this quote recently: the most dangerous lawyer is an uneducated, uninformed lawyer. So on both sides. So that's the goal. The more information, evidence, and you can share playing chess, not checkers, the more likely you can get to a result quicker. And the quicker we get the result is, I'll conclude by this, on this point. I believe in litigation, 90% of the time, only the lawyers win. I've tried a bunch of cases, and I frankly have won a lot of. I've won 95% of all the cases I tried because I know which cases to try. I'm not saying I'm a great trial lawyer. I'm really good at knowing what cases to try. But I've never had, after we tried a case and won, a client look at me and say, you know what, this has been the best 18 months of my life. And I'm glad I spent 2 weeks with you here at your trial instead of making widgets. I want to do this again. No one has ever said that to me. It's a painful, painful experience. And that's why only 1% of all cases ultimately go to trial.
Because at the end of the day, the motivation is to get this, behind them as soon as possible, as quick as possible, and being able to find someone like yourself that's able to, collapse that time frame. Now, I am wondering a little bit as you're talking, Bill, in regards to perception as well as human behavior and human psychology. So I was talking to a friend of mine, and he was a trial lawyer, and he had to drum up a story, right? Because obviously you're trying to convince individuals for your case, and in that circumstance, you use data, but you sprinkle that into a story that you're facilitating.
Right.
How much does that apply to when you are negotiating, in that circumstance and the conference table? Do you have to drum up, or is it more of just that data back and forth and saying, well, in this circumstance, and like you just mentioned, it's more of like, hey, strategically, this is what we have. This is what you don't have. This is the reason why you should, negotiate. And 500,000, that's what we're going to do, instead of you're asking for 1.5 million or whatever the situation is. So how much do you have to drum up the story, or is it more of just in that circumstance, outside of the trial, it's more of just the data and negotiating and more that, perception and making sure that you're deploying that effectively?
Well, I think, again, you got to figure, you want to play the cards that you feel comfortable playing that won't come back to boomerang on you. And yes, I mean, that's, if you get an eye to eye with the other side, you understand many times plaintiffs' lawyers are a filter. So whatever you tell, if they want more money, they may not tell their client what I told them. So if we can arrange a scenario where I can have face-to-face with some actual plaintiff who's the one that is the real decision maker in a case, it's way more effective than me telling some lawyer who then tells their client what they want them to hear. So you want to do, and so the other thing you want to do is, so you want to educate the plaintiff many times, not all times, because there's exceptions to every rule. I'm not trying to say 100 out of 100 times, there's exceptions all the time. And you want to frame the issue. I've been in cases, I do mostly big cases. So, I'm doing cases that are worth anywhere between a million or two to $50 million. That's what I'm doing nowadays. And I'm flying around the country doing mediations on huge cases. Some of the lawyer might handle a case in Chicago, and then I'll fly up, and take over the mediation and the negotiation. I've been in cases, I call it, you have to frame the issue. I've been in cases where, the plaintiff is, there's a chance they could get a zero, but there's a chance they could get $10 million. And I'll walk into the case and say, ma'am, and this is unprecedented. When I did this in a mediation a while back, they were shocked, but it was effective work. I said, Mrs. Johnson, you don't know me. I flew all the way from Atlanta to specifically meet with you today to try to get this case settled. And I'm gonna promise you one thing for sure today. When we're done negotiating today, you will never have to work again. And the question you'll have to decide is, do you take the deal today where you'll never, ever have to work again? Or we're going to go to trial, and Mr. Smith here, the Chicago lawyer, is going to try the case. And if he wins and you get a zero, you know what will happen the following Monday after trial? You return to the United States Post Office and you have 10 more years to work there. That's what my goal today is. I don't want you ever have to work again. So you had a plaintiff who came in wanting 10 million. And let's face it, somebody who worked for the United States Post Office and made 75, 80 grand a year, if they got $1 million or $2 million, they are set for life. Now, it's not 10 million, as I tell people, to help quantify it, I'll tell people, we're here today where you're going to get the Cadillac money. But if you want the Lamborghini, you're going to have to get it from a jury. Because you got to have people realize, yeah, 10 million is a lot, but your life changes at $1 million or $2 million. If you get $1 million or $2 million, your life completely changes. Yeah, 10 million would be great. But so really, really good lawyers are great at framing the issue in a way that's most appealing to the plaintiff. In some cases, I have death cases where the plaintiff doesn't care about money. They do, but they don't. They lost their daughter. They lost their husband. And in those cases, the leverage changes. The leverage may be, I've been in cases where I'll say, there's nothing I can say or do today is going to make this you right. I know it isn't, but here's what I hope happens today, Mrs. Johnson. You lost your daughter. We're terribly sad and sorry you lost your daughter. The one thing we can achieve today, if we can resolve this case in mediation, is closure and some financial security, because the alternative is this is going to go on for the next year in discovery, then a trial, and then an appeal. And for the next 3 years, your lawyer, who's a really, really good lawyer, is going to be reminding you daily of your daughter's death, because he's going to be telling you about the case and reporting you on the case. So today's an opportunity for us to find a way to honor your daughter, give you all what you deserve, and allow you to have some closure, to think about the good times and move on, right? So every case is different. And again, I'm telling you stories that have nothing to do with the law. Really, they're about what is appealing to that person that will motivate them to want to resolve the case. And sometimes you have to remind them. And sometimes I look at the plaintiff's lawyer and I'm like, yeah, that's actually right. That probably would motivate us to get rid of the case. So, and trust me, there's times I've been wrong, but really good lawyers and claims people, GCs, risk managers, can look at a case and figure out what will motivate the other side to resolve the case. Sometimes it's fair. No, sometimes you just know someone is anxiety riddled and there's no way they want me to be in trial cross-examining them. So you subtly throw in that. And it's a truth. I'm not intimidating them. I'm telling them the reality. You're about to go on, you're going to sit here for a week where you're going to be the focal point and a lot of people are going to be beating you up. Is that worth the pain and suffering of us trying to resolve it today? So there's a lot of tactics in this kaleidoscope of leverage points to resolve cases.
That is so golden, and why it's so golden. And I really appreciate you unpacking that, Bill, at a micro level, because it's like understanding at the end of the day, what does that individual want? And then be able to give it to them, and then reframing the whole situation, say, hey, we can take care of this right now within the week or week and a half right now. We can, sign the paperwork, rock and roll, or we can drum this out for another 18, 24 months, which nobody wants to do. And that's going to be a constant frustration, constant annoyance. So reframing that whole thing. So really reiterating that's part of the negotiation process when you're having these conversations, dialogue. And like you mentioned, you are talking some high, mid seven figure, 8 figure, checks, right? Some big, court cases and so forth. So nobody wants to go to that direction. I am intrigued by preventative measures, right? So once this happens, right, then the company looks internally, or whoever's working with you, Bill, and your law firm, and they start looking, okay, well, what can we do to ensure that this doesn't happen again? With that conversation, do you help them or almost kind of give them some guidance in regards to saying, hey, to ensure that we don't get ourselves in this circumstance, make sure in your legal documents or your onboarding or whatever the situation is, make sure you do these things to ensure that obviously you can mitigate that risk?
Absolutely. Absolutely. Because, well, there's many lessons learned during litigation, because companies who think they're tight with their HR policies or employment policies or tight with their safety protocols usually learn in litigation that maybe they had protocols, but they weren't followed. Or, how many cases we get where there's all these protocols and they're really tight, and the tractor trailer driver who ran over somebody and was on meth, we found out, he got an accident 6 months ago and he was supposed to get the drug test and he didn't get it. And people are like, oh my, how can that happen? And so in litigation, the legal burden of proof is on the defendant. On the plaintiff. So in a civil case, the judge charges the jury and says this: ladies and gentlemen of the jury, the plaintiff has to prove by a preponderance of the evidence that the defendant did blah, or the defendant was negligent. Preponderance of evidence is more likely than not 51% essentially. So our industry on the defense side, I'll be in trial counsel. Where the case, I'll helicopter in to consult on, oh, this case is going to trial in a month. What do you think? And everyone's saying, well, the plaintiff can't prove this, can't prove that, blah, blah. And I say, stop, guys. These juries, it's a subjective standard. I believe the burden of proof is actually on the defendant, and the burden of proof is literally this in most jurisdictions, except especially liberal in inner city jurisdictions, that you need to prove your case such that when the jury goes back to the jury room, they say, I don't know what else that defendant could have done. That's the burden of proof. So in risk management, I say, that's what you got to do. You can't sit there and say, well, you know what? That's not our problem, but I looked at the law and we weren't really technically required to do that. I tell them, assume it was your family driving on the street with that trucker. Is he buttoned up that you'd be comfortable that? We do a bunch of apartment cases where there's assaults and murders and rapes. And the argument will be, well, we can't afford a security guard, or we have one security guard. And I'll ask them, let me ask you a question. If you lived there or your daughter lived there, how many security guards would you want here, given that there was a rape 6 months ago? That should be how you look at risk management. And it changes your paradigm and approach. Because when you look at the law, though it seems black and white, and you could say, well, no, I'm not required to do that. Juries don't look at it black and white. They look at it as gray, and they look at fairness and equity. And we on our side have to start thinking, and we're doing a better job. Plaintiffs' lawyers forever have done a very good job of telling stories. It's called the reptile theory. They do a good job of making the defendant a bad defendant, an unsafe defendant, and we need to send a message by walloping them with a huge verdict so they'll fix what they're doing for the future. And we walk in with these very, very unsympathetic stories about, the law says this, we didn't have to do that, and besides, it's not as bad as you think. Those aren't good defenses. And so, again, in conclusion on your question, as a risk manager, you should be looking, if it were my kid, my family, my wife, whatever the scenario is, what would I want done? And on top of that, there's great value in mitigation. Sometimes we just mess up, and lawyers are ruining the world by telling their client you can't apologize, or you can't freeze, don't do anything. It suggests guilt. Look beyond that. You know how much, if you mitigated, I had a case where, I apologize for war stories, but I think they give context. I had a case where I get hired on an employment case, and it was a scary case. So they bring me in, and they had another lawyer on the case, and they bring me in a large famous restaurant. At the end of the day, the manager stands up and says, there's $400 missing, and we looked at the video. Jonathan, you took the money, you're fired. In front of the whole staff, fired Jonathan. 2 days later, the owner looks at it, the video closer, and says, Jonathan didn't take any money. I'm looking at the video, he didn't do it. So they didn't really do anything about Jonathan. Then the employee hires a lawyer, and they write a letter saying, hey, you wrongfully fired my guy, blah, 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 blah. And the lawyer for the restaurant had a letter this long, go to hell letter. And I'm like, freeze. Are you crazy? We messed up. We're at fault. Stop. We are in mitigation mode. And literally, know what we did? One, immediately tell Jonathan he can come back to work. We knew he probably wouldn't want to, But one, tell him he's going to come back to work. Two, you announced to the whole staff that Jonathan was a thief. You now need to have a meeting immediately and announce to the whole staff, you made a mistake. Jonathan's not a thief and we want to rehire him. Three, you need to put a letter up in the lunchroom or the break room saying, for the people who may not have seen or were attended at the first meeting, but not the second meeting, that we wrongfully fired Jonathan. He's not a thief. Four, we're not going to send that letter that told him to go to hell. So once we do all these things, I call up the plaintiff's lawyer and say, you know what, you're right. We messed up, but we've unrung the bell the best we can. How much you want? We knew we were going to pay something. We know we're going to go to trial. So I know immediately my client is negative $100,000 just paying me to go all the way to trial. We sell a case for like 15 grand. And I billed like 5 grand. But, you know, once we unrung the bell, because the plaintiff's lawyer wanted to go to the trial and being able to say, you know what they would have done with the go to hell letter? They would have said, they fired the wrong guy. They know they fired the wrong guy. And then they tell us to go to hell. You, ladies and gentlemen of the jury, need to tell them to go to hell with $1 million verdict, right? I mean, they called him a thief. We sell the case for 15 grand. And I'm not saying it's a great result or a bad result, but cost of defense wise, it's a really good result. And so you, again, it's a critical eye and it's somewhat unconventional because 9 out of 10 aren't thinking that way because they've been told don't think that way. So you got to be thinking that way to mitigate and just to do the right thing. Sometimes it might cost you money to do the right thing, but it's better to do the right thing because I think juries are more willing to forgive if you immediately after what happened, try to do the right thing.
I love this approach, Bill, because, you know, I think lawyers do, and definitely when they're defending larger corporations, they get a bad rap because of those kind of, you know, slick things. We know that the wallet size of a corporation is so much bigger than an individual, right? And so they can obviously deploy a lot of capital. They can, you know, have this situation litigation run for 24 months, and that's fine because they can obviously fit the bill. But what I love about your guys' approach, and it's so unorthodox, and that's why I wanted to have you on as well, is saying, hey, you know, we're going to take ownership and we're going to have empathy. We're going to obviously make sure we, you know, navigate this situation for my client in the most proper way possible, but also we're going to do the proper things, right? It's saying, hey, we're going to look at the whole contextual situation. And in that circumstance, saying, hey, we do take ownership. We did the wrong thing. And then instead of making 100, 150, 200,000, $1 million situation, big news thing, right? Whatever. Now, all of a sudden we're able to dial it and say, hey, look, our risk is 15K, 5K to them, whatever, and solve the problem, solve the issue. Because at the end of the day, as it gets even further and further down the road, it becomes an even worse situation, worse, et cetera, et cetera. And we've seen that. I think there's a lot of circumstances that we have seen that over and over where these corporations or whatever, and lawyers tend to push that way. So I appreciate what you're saying in this regard. When you're coming to these, so we're talking about preventative stuff, which is really awesome. I'm also intrigued with when you're building out that foundation and having these conversations, because you mentioned something in regards to like taking on a case that wasn't yours fully. Because sometimes I've had these conversations where these corporations, they go to one law firm and it took 18 months, they didn't get anywhere with it, and then they have to come with you, right? And so at that point, it would have probably been better to start with you because you could have been able to like collapse that time frame, solve the problem, be able to do it strategically. However, though, they chose the wrong individual. And a lot of our listeners, I think they've been in this situation where they chose the wrong law firm and they're like, oh crap, this is worse than the problem. In those circumstances, how do you navigate that kind of situations that have kind of like the nails that have already been hit in the coffin, and you're like, okay, well, now we have to kind of turn back the dial a little bit, and how do we, you know, kind of restructure the foundation even when the foundation's already weakened because of the lack of integrity or lack of situation for the other law firm? Because I would imagine probably some cases have been in your, you know, in your arena that was like, oh crap, this law firm really messed it up.
Well, first of all, I want to be careful. I think there a minority of law firms is a lack of integrity. A majority is a lack of philosophy or skill set. And I've learned the latter mostly because as we've gotten bigger and bigger and more busy, I brought in lateral lawyers, senior lawyers, to plug them in and realize you can't rewire them. If they don't have this philosophy, it's hard to change them, number one. And number two, even if you can change them, that doesn't mean they have the skill set to get it done. And that's why this is so complicated. And I like using football metaphors. And here's my metaphor for this concept. If I want one day, and I think they almost did this on the NFL Live the other day, I want to have a video of a defense, and I want Tom Brady to look at the video and tell you what he sees. And I guarantee you, when he looks at the video of that defense, when he looked at the line, he can say the right cornerback is going to go deep. The left linebacker's coming in. Just because he's a poker player, he can see the tells. He can read what everyone's going to do, and he knows where the hole in the defense is. And that's why Tom Brady's the GOAT, because he can read, and he's probably a better poker player than he is a football player. He can read people and read defenses. Blake Bortles, not to pick on him, walks up and he's like, well, I don't think they're really doing anything. I don't see anything. And Brady throws a touchdown because he finds the hole, and Blake Bortles throws an interception because he didn't see anything. Lawyers are the same way. Really good lawyers can look at a case and see things. They can go to a mediation and see in the discussions, hear in the tone that they're bluffing, see in a blink of an eye that they're not sincere. So how do you find that person? The best way I think of finding that person is you need to play Moneyball. My firm, we play Moneyball. We keep track of metrics. And what's crazy is the insurance and big box retail, et cetera, they're doing a better job of this. Most of them don't have. I do metrics, and I'll go to my clients, many clients, and say, hey, you gave us X cases last year. Let me show you what the average cost of the case was, the average life of the case was, how many depositions. We used to take depositions in 90% of our cases, and depositions are expensive because they're like cockroaches. It's not one, you take 5, 8, 10, and then you want more documents and blah, blah. And next thing you went from 20 to 50 to 80 grand. We take depositions in 25% of our cases from 90% 15 years ago. So because we have these tactics to informally share information. So what surprises me when I take this I'm talking about billion-dollar companies it's insurance companies, that there are litigation machines. That's what they do for a living. And I say, hey, here's my numbers. Here's my Moneyball metrics. What do you think? And they'll be, wow, this is very impressive. And I say, okay, how do I compare to my competitors? And 99 out of 100 will say, we can't tell you because we don't keep this data. We don't know. Insurance companies, for every dollar of premium they get in, over 50% goes to litigation, expense, and settlement. If 50% of your spend went to those two things, wouldn't you vet very hard, very, very hard your lawyers as to them being great and you know 92% of all cases settle? Wouldn't you vet really hard your lawyers? And to tie this in, I got a call a year ago from a Fortune 500 company, and they said, hey, we've read about you, we've heard about you, we want you to do an RFP. We're going to send you our form. Great. The guy sends it to me. It's 10 pages, and they want to know ad nauseum every case I tried, every result I got. And I called the guy up and said, hey, I will do this. It's going to take me a day, literally, because you want 25 years of information from me. Before I do it, I have one question for you. How many cases do you try a year? And he said, oh, are you kidding me? We got walloped for $5 million 2 years ago. We don't try anything anymore. And I said, then why are you asking these questions? Why don't you ask dealmaker questions? What percent of your cases you resolve in 60 to 90 days? What percent of the cases, tell us a negotiating story where there was $1 million of authority and you got rid of it for 400 grand. If 92% of all cases settle, and of those 92%, probably 60% we know are going to settle. We just know based on how they look, they're going to settle. At least And then there's 20 or 30% that they're going to settle, but I need a little more information. I need target information. I don't need shotgun information. I need to know one or two things. How do I get that? Do I spend 50 grand of deposition? So I call the plaintiff's lawyer and say, I need A and B. You got it? Let me see it. You know? So the philosophy needs to change. And I get indignant about this, and I apologize. It amazes me again, if 92% of all your cases settle, why this industry is not laser focused on deal makers, especially when 50% or more of all of their spend is on lawyers and settlements. And, you know, and I have insurance companies who will say to me, well, Bill, you don't understand. We do not want a reputation of being a settlement machine. We are not that. We don't want that reputation. I'll say, John, that's fantastic. And you define a win. I'm not defining wins for you. What I'm doing is I'm just giving you reality and telling you to change your game plan in reality. So I have a simple question for you. I know you don't want a reputation as a settling company. So let me ask you a quick question. How many cases you tried last year? And they'll be like, I think 2. And I'm like, you're $1 billion, you know, bottom line is the percentage will be like 0.6%. And I'm like, well, I know you don't want a reputation that you're a settling company, but at the end of the day, you are who you are. You're a 0.6 try company. So why don't you acknowledge that reality? And that's fine. Go put those cases in the trial bucket, put 10%, we're going to try 10%, put them in the trial button, hire General Patton, who's the greatest trial lawyer, and go try those 10%. And then the other 90%, hire Henry Kissinger, great negotiators, and go get them done. And you'll save millions, if not billions. So I just vomited on you, but it felt good.
Dude, yeah, it felt good on my end too, because this is so relieving. I love what you're saying, because again, I've talked to some individuals that have that orthodox where it's like, hey, our DNA of our company, we don't want to settle. But what you're saying, Bill, is look at the data. The data is saying, hey, 60% of these for real, 100% will not actually go to trial. So why don't we, solve those and ask the right questions and have the right paradigm and the right mindset and the mental model, if you will. So I love this. Now I want to ask you and loop back around in regards to, I had a friend of mine, and now this is totally irrelevant, but I'm curious the context. So he went to a divorce lawyer in this jurisdiction. They tend to go toward a little bit more to women, and he lost his kids, blah, 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 the situation, whatever. My curiosity is the same that goes with this corporate kind of litigation stuff. Is it really dependent upon the jurisdiction, right? So some states may be a little bit more leaning toward, like I know, for example, if you're in the real estate side of things, California tends to lean more toward more of the individuals that are renters, right? More so than the owners, right? And that you can just anticipate that. So I'm curious, is that the same? And if that is the same, like it's very contextual and you want to obviously navigate that correctly, do you navigate that? How do you navigate that to ensure that you are in a jurisdiction that will most likely, if you do go to trial, which is very unlikely, but even maybe the circumstances where, hey, this is in favor of your client?
Well, it's a really good question. The unfortunate reality is we don't have much control over that, because jurisdiction is decided by things many times outside the defendant's control. It might be where the incident occurred. So if it's a trucking case and the accident occurred in DeKalb County, Georgia, you're likely stuck in DeKalb County, Georgia, which is, not very good for a defendant. You can do one thing a defendant can do, a corporation can do, is have their registered agent in a very conservative venue. In Georgia, it used to be Fulton County, then it went to Gwinnett County, and literally now I tell my clients Cherokee County. So sometimes they have to sue in where your registered agent is. You're just going to get a more conservative jury in Cherokee County. And I tried a case a few years ago. It was a catastrophic case in a conservative jurisdiction outside of Augusta. We got a defense verdict. If we would have been the next county over, we got hit for $10 million. It's that simple. And so when we do our evaluations, that comes in. That's a big factor. And plaintiffs lawyers know it too. They'll say, hey, I understand all your arguments. I get it, but a decap jury just won't care. They won't care. They're going to wallop you. And we got to deal with that.
Gotcha. Okay, that makes sense. That makes sense. But it's you don't have much say in that, and that's why I was wondering a little bit, because I do know some circumstances. Okay, gotcha. Awesome. And I want to talk a little bit about, before I let you go fully, Bill. First of all, I really appreciate the immense value that you brought, and I know that you have just immense experience. I love your unorthodox way of doing this, having this conversation as well, and being empathetical in the way you approach it. But I want to talk a little bit about some series that are coming up. From January. You've done this numerous times, but I want to obviously bring this to our audience, because no matter what industry, I think this would be very, very, very valuable. Okay. Your 40-minute webinars to improve your negotiation skills and approach to settlement. And again, these are applicable negotiation skills. So session 1, session 2, please tell us a little bit about your mindset behind it. What's your goal with it? And then as well as how do they access it for those that are listening?
Great. Well, thanks for asking about that. So bottom line is, based on my experience, like I told you the story where clients and potential clients weren't getting much education on negotiating, given the fact that 92% of all cases settle, I decided 2 years ago to create a negotiation course called the Masters of Negotiation. And it's a 10-point course. It started out like 7 or 8, but through feedback, we're up to 10 now, and they're 40 minutes because, I know everyone has ADD now and they can't, they're not going to last more than 40 minutes. So it's 40 minutes in and out. And I'll tell you what, we'll have a couple hundred people on the call and 99% stay through minute 40. So that's how I measure if it's good or not. My feelings get hurt if people drop off, at minute 25 or 30. That means I bored them to death. So they are entertaining. They are informative. I get feedback. A general counsel, 25-year lawyer who's been a general counsel for over a decade, emailed me and literally said, I was skeptical when I was going to apply to listen to this thing. And I literally have learned stuff I didn't even know I didn't know in this course. So there are 10 courses from, I got them. I actually got them. I'm writing a book. I'm writing a negotiation book based on the courses. So, the first one is playing chess instead of checkers, the strategic approach to negotiation, the theater of mediation, the leverage point of educating the plaintiff's counsel, the leverage point of the plaintiff's needs. We've kind of touched on those things. The soft skills of a great negotiator. Sometimes, really, really good negotiators can get the other side to communicate and open up and develop a dialogue, where bad negotiators and communicators are in a fist fight for 9 months and bill 50, 100 grand. So it's a 10-point course, and you can go to cmlawfirm.com to sign up, or you could email me at bmitchell, BMITCHELL at cmlawfirm.com, and love to have you. It's free. And we are getting CE courses. They'll probably be blessed for CE courses. They start in January, I believe. January. I don't have it in front of me. Is it January 18th? I think you can look at the website.
Yes, January 18th. Yep, correct. And then I think the 25th as well. And so Bill, again, I really appreciate that, guys. For those that are listening, those links are in the description below. That is cmlawfirm.com, and everything is right there on the top there. You can go to Master Negotiation and sign up. I'm going to be partaking in it as well, just because I'm always intrigued by learning from people like Bill, that is actually in the trenches and actually utilizing these negotiation techniques in real time. Again, Bill, I really appreciate you being on. I always love to ask my guests, before I let you go fully, is there any last words of wisdom they'd like to share with their audience?
What's 100 lawyers at the bottom of the ocean?
What is it?
A good start. That's what I'm trying to change. People don't like lawyers, including their own lawyers, because many times we're complicators. And the goal here is to be very good at resolution focused. And so at the end of the day, people look at their lawyer and say, you know what, They were resolution focused. They were business focused. They gave me a business solution, and I got a great result for a reasonable price. And I'm glad our philosophies aligned, because right now in this industry, I feel like philosophies between clients and lawyers do not align. And my goal is to get them to align. And so maybe one day that joke will be, what's 100 podcasters at the bottom of the ocean? It will be that joke instead of lawyers.
Well said. Well said. Guys, that is my friend, the founding partner of Cruser Mitchell Law Firm, my friend, Bill Mitchell. Guys, that is Journey with Christian D. Evans podcast. Until next time, be uncommon if you can. Yo, this is Christian D. Evans, Journey with Christian D. Evans podcast. We thank you so much for listening to this amazing episode. If you feel and you know that this was valuable to you, please show some love to our amazing guest by liking this, by commenting on this, by making sure that you do a nice 5-star review and just show some love to our guest. That'd be really awesome. Also, make sure you share this with a friend, a family, a colleague, someone that you believe would bring value to their life right now. And guys, we just want to say thank you again for just being part of our community. If you want to have more resources, don't be afraid. Go to christiandevans.com. You can actually schedule a phone call with me, or you can send me an email at christian.evans@beUncommonIfYouCan.com. That's christian.evans@beUncommonIfYouCan.com. Always love to hear some feedback, and let me know what is the number 1 or 2 things that you are struggling in your business and your life, and we'll make sure we have those conversations. Guys, that is Journey with Christian D. Evans podcast, and until next time, remember, be uncommon if you can. Cheers.